Good morning, everybody. Welcome and thank you for being a participant today in Greenspoon Martyr's Innovation Summit. And in particular, thank you for signing up for this particular session entitled The New Virtual Workplace. Many people call it the work from home revolution. For those who have worked with me before, you know how passionate I am about this issue. 27 years ago, when I started being an employment lawyer and an HR consultant, work from home was a very peripheral, minor concept. It would only come up in the context of the Americans with Disabilities Act and a situation where perhaps one employee once in a while needed to work at home because of some extenuating circumstances. No longer is remote work on the periphery. It is now at the epicenter of HR work. It is at the epicenter of employment law. And hopefully today we'll be able to cover some issues that all of you who signed up for this will find meaningful and, even more than that, relevant to your workplace. Good news is we have a great panel. I'm going to introduce them shortly. Bad news is we have about 5 hours of material to cover in 45 minutes. So we're going to move relatively quickly, but here's my offer to all of you. There are certain issues we're not going to cover, we're not going to have time to cover, but stay in touch. Keep sending us your emails, your text messages, your phone calls, because together we believe that we can work with companies anywhere in the country and navigate through these issues, which really are complicated. And even more importantly, they're very new. Many of these issues simply did not exist in this fashion prior to COVID-19 7 months ago. Let me first introduce some panelists here. With me from New York City is Eric Adler. Hello, Eric. Good morning.
Good morning.
Eric Adler has been with Advanced Local, I believe, or the Advanced entity since 2005. He normally would be communicating with us from his home office at One World Trade Center in Lower Manhattan, but consistent with this theme today of virtual work, Eric, it looks like you are in your home. I thank you for being here. For anyone who knows anything about media or publishing, Advanced Local is one of America's largest, greatest media companies. Advance was founded back in 1922 by Sam Newhouse. It remains a family-run business, and millions of people a day receive their information and their news and their entertainment and their culture from Advanced Local. Eric has worked at some of the greatest law firms in the United States as an employment lawyer, and again, has been with the Advance related entities for about 15 years. So Eric, thank you for joining us. Alex Leyva is with me as well. For anyone who's watching who's worked with me before or worked with Greenspoon Martyr on employment law issues, you probably know who Alex is. He joined our firm in 2014 as a summer associate in law school. 6 years later, he is still with us, and he has become an invaluable part of our Greenspoon Martyr employment law team. Alex, thank you for being here as well. 3 things I want to mention briefly, and then we're going to get going to the panel discussion. Many of you have reached out to me before this morning and asked that I speak to you about the following 3 issues because they are important, they are new, and they are very pivotal in how we run our places of business. The first one I'm just going to mention briefly because it could be an entirely separate seminar, is the issue of vaccinations. People have been calling me asking the following question. When we finally have FDA approval on a vaccine, may I, as the employer, make the vaccine, taking the vaccine, a mandatory condition of employment? And what I'd like you to consider today is the following. Consider it a homework assignment. There will be FDA approval at some point, maybe this year, maybe next year. What I want you as an employer, as an HR manager, as a CEO, what I want you to think about is, are you going to fall into 1 or 2 camps when it comes to the vaccination? Either camp is fine, either camp is legally valid. Camp number 1 means that you will make it mandatory. Just as you require employees to do a background check, fill in an application, sometimes take a drug test, perhaps sign a non-compete agreement. You will add to those lists of conditions for hire that they show you that they have taken the COVID-19 vaccine. There's certain exceptions for disability and religion, which we're not going to get into. But I want you to decide if you're going to be in that camp, we'll call it the mandatory camp, or are you going to be in what we call the optional camp? You won't make it mandatory, but what you're going to tell your employees is that you're going to encourage it, you're going to facilitate it, you'll probably subsidize it, and you'll hope that employees will follow your lead. Here is the issue that I want you to think about, and we will handle this in a future seminar as well. If you do what most companies will predictably do, which is to make the vaccine optional and not mandatory, there is an issue now in our country, we refer to it in employment law, doctors as well, calling it vaccine hesitancy. So what I mean by that is that all the empirical data has shown that if you have 1,000 employees, for example, at best, half of them, 500 will ultimately be vaccinated, 500 will refuse to do so. And what I want you to consider, if you're going to fall into that optional camp for next year, is the following issue. If half your employees are vaccinated and half your employees are not, how are you going to be received by the employees who are vaccinated? And the answer is they're going to be concerned. There'll be some unrest about it. Some of them will want to continue to work from home. You will continue to deal with PPE issues in your workplace, masks, elevator capacity issues, cubicles being removed, lunchrooms being closed, plexiglass, social distance, etc. My point is, even when we have the vaccine, these issues of remote work are going to continue, and they will continue for years. So I want you to be prepared for this issue and understand where the missteps can be and what the repercussions are. Final issue I'm going to throw out there, and then I'll turn it over. For companies who are participating today, if you have fewer than 500 employees, you are still subject to the FFCRA, the Families First Coronavirus Response Act. You are subject to that law and all of its paid leave requirements until December 31st, 2020. It may or may not be extended. We will keep you posted on the future of that law, but there's a good chance the law will be changed and or extended into next year. And because many of you are now dealing with paid leave requirements, mandatory federal requirements on paid leave for the very first time because of this new law that went into effect in March, I need you to keep up with that law, and we will be in touch to see if it extends into next year. Those are my thoughts on vaccinations. Those are my thoughts on the FFCRA. Now we will begin with the panel. Eric, I'm going to turn it over to you on a question and an issue that you and I have spoken about before. The question of when and how to reopen. The question of making that decision, especially for a company like yours, Eric, like companies who are on the phone and on the video conference with us right now. You are in multiple states around the country. Advance has thousands and thousands of employees. You have essential employees, you have non-essential employees. Please tell us how you are navigating through the issue of reopening and reentry.
It's a very delicate question, Peter. We have a footprint all across the country. Each market is different. The rate of infection in each market is different. People's mindset about the virus is different in each of our markets. Our guiding principle is the safety of our employees, the health and safety of our employees. So we are going to be and have been very conservative about re-entry into the offices for those employees who are currently working remotely. First, we will not even consider any re-entry into any of our offices until the infection rate is below 5% for that state. So it's a non-starter. If it's above 5%, we won't even think about it. Second, if it's below 5% and there is a real business necessity of asking people who are currently working remotely to come back into the office. We will evaluate that. We'll see if it's a real necessity or whether it's a nice to have. Again, we're not inclined to reopen offices until we have more information, probably not until after the first of the year. It is much easier, in our opinion, with people working so well remotely, and people have been spectacular. They have been doing their jobs. They have been excelling at their jobs, working remotely. We would prefer to continue along these lines rather than bring people into an office and then if an infection rate spikes, have to close it down again. So we're proceeding cautiously in that regard. You mentioned that we're a news media company. Election day is coming up, and there's going to be a lot of activity surrounding the elections. Our reporters have a real desire to be in the newsroom in the days leading up to the election and the days following election day, which may not be decided until after the election. We are evaluating whether this is a necessity again, and if so, identifying only those people who need to be in the office as a consequence of their job. For those people, we are making sure that they get tested. Nobody is entering unless they have been tested, and it's a negative test. On the day that they report, their temperatures will be taken, and they will be certifying that they do not have any of the COVID symptoms. Nobody gains entry unless that happens. We're also preparing our facilities. We have a very, very extensive checklist about what we'll be doing in the facilities. We will be limiting entry to only those who have an absolute need to be in the office. We are limiting it to less than 25% of the folks. Again, mitigating density in the workplace. There will be no access to high touch areas like the cafeteria, like the coffee makers, things of that nature. There will be plexiglass partitions. We will be marking with tape where people should be walking, where people should be sitting. But again, none of this happens unless the state in which they work has less than a 5% infection rate. I mentioned people currently working remotely. Our reporters, while they're not reporting to offices, these folks have been out and about in the community doing their jobs, reporting, covering protests, and we might get to that a little bit later in our conversations. Anybody who is going out and performing their functions in the community has to self-certify that they've taken their temperature each time before they go into the public, and that they are not suffering any of the COVID-19 symptoms. That's a very brief outline of what we've put into place.
I think that raises a very important issue, and it's an issue which our clients have brought up with us on numerous occasions. For every company, I don't care if you have 1 employee or 10,000 employees, keeping your employees safe is sacrosanct. There is nothing more important than that. And I think what Eric is talking about in terms of his company, there's so many different positions, so many different job descriptions. Some people in Portland, Oregon, covering protests, covering riots. Other folks who have come back to work are inside of an office, and you are doing a very efficient job of keeping them safe. But this question of employee safety is huge. And Alex, to talk to you about this issue. The issue of workers' comp we've dealt with for years and years. And workplace safety we've dealt with for years and years. But workplace safety always was, do you have a camera at work? So when people walk in, we know who they are. Do you have password protected entryways? Do you have a good alarm system? Now, with so many employees at home, with workers' comp claims actually increasing, which is fascinating, not decreasing, but increasing. Alex, shed some light on the issue of workers' comp today in the context of remote work, and specifically what companies should be doing.
Thank you, Peter. And as you mentioned before, unfortunately, you and I specifically have dealt with this rise in workers' comp cases. And the strange thing about it is that many companies, many of our clients, don't realize that workers' comp and the laws pertaining to it, whether you're in Florida, Texas, New York, still apply to the remote work arrangement. In other words, if the employee gets injured at home, that is still potentially a workers' comp case if that injury occurred or arised out of work being performed on behalf of the company. And we can go through countless examples that we've already dealt with, but here's the most interesting one that you and I have seen thus far in the 6 months that we've been in this remote work arrangement. Okay, and this is going to be a little insightful for all the participants. There was an employee who was working from home, and that employee, on the way to obtain a document from the printer that was in another room, tripped over her son's toys. Okay, that injury occurred between 9 to 5 while the employee was on the clock and while trying to retrieve a document she printed for work. Now, our client pretty much said, hey, why do I have to pay for this? Why are we being held responsible for the mess that employee had in her home? And whether or not it was a mess, it was a misplaced toy, that doesn't matter. And the simple answer is the injury occurred not only while on the clock, but also while doing work-related or business-related tasks. And that is the bottom line. That is straightforward, that it doesn't matter where the injury happened, it still happened while performing work on behalf of the employer. Now, the next question, as you guys could all imagine, was what can we do to prevent this? Because quite frankly, we cannot have someone at home supervising the employee while sitting in front of the computer, while monitoring her everyday move. And the answer is simple. And it's going to be a topic that Eric and Peter and I will go through over and over again today. There needs to be a comprehensive, effective telecommuting policy that addresses multiple issues. Okay? With respect to this workers' compensation dilemma, Peter, it needs to address what are the expectations while working from home. Okay, what are the ergonomics of the workplace? In other words, is the employee being required to set up an efficient workplace or workstation? Okay, does the employee fully understand that the work is to be performed from 9 to 12 and then a lunch break of an hour and then from 12 to 5 or 1 to 5? And the reason why that's important is because if the injury happened before 9 o'clock, or if the injury happened during an unpaid lunch break, or if the injury happened after clocking out, the chances of the employee arguing or successfully arguing that the injury occurred or arose out of the work are much slimmer. So that telecommuting policy will address those concerns, will address the requirement that employees immediately report injuries, will address the requirement that employees should set up efficient workspaces, clean workspaces, and be held to similar standards that they would otherwise be held to in the workplace.
No, I think that's a great point, Alex. And I think the issue that we are seeing from companies, and Alex, you know this because you probably work on more employee handbooks around the country than anyone I've ever met. We are being faced with HR issues and HR inquiries where we will ask the client, after hearing what the problem is, we will ask the following question. Send us your policy on the issue. Send us your employee handbook, which specifically addresses, and I'm not being facetious because this has happened, but the situation where someone working at home goes to the refrigerator during lunchtime, grabs a piece of cheese, falls down in the kitchen, and then our company gets a claim for workers' compensation benefits. The client calls me up, doesn't understand why are they responsible if someone tripped in their kitchen, getting a piece of cheese, Alex's case that he mentioned with the kids' toys. These sort of situations globally need to be addressed in your employee policies and procedures. Because here's the deal that all of you know. 98% of your employees out there right now do not have employment contracts, okay? Maybe they have offer letters, but they don't have extensive employment agreements, which means that if you run into an issue at work, if you run into an employee who wants to make a legal claim against your business, a judge in any of our 50 states is going to defer to that handbook, is going to defer to that policy. And Alex and I have become sick and tired of getting handbooks this week, next week, the following week, which simply are not prepared to address what's coming in 2021, which is more remote work. Now, frankly, the past 6 months, we all thought this was temporary. You know, a lot of handbooks are sufficient in terms of what they have maybe as of today, but now we know, even with the vaccine on the way, the remote workplace could go on for years and years, as we've said, and your policies need to reflect that new reality on a whole host of issues, whether it be workers' compensation, whether it be electronic communications that we're going to talk about in a minute, whether it be employee chat rooms and how employees are conducting themselves with one another. These issues need to be viewed through a 2020 prism. And a handbook that was written in 1988 is going to be obsolete, ineffective, and will provide no benefit to you in the event of an employee challenge. Eric, I'll turn to you on this next question because this goes to policies as well. You made a comment, Eric, about production and work and the dedication of your people. And I am hearing that from companies and companies throughout the country, that one thing that they weren't, well, some were, but some people were not prepared for the following. Employees in certain ways are working longer than ever. Employees are taking less PTO than ever, fewer PTO days than you can ever imagine. But at the same time, while production has been excellent with many, many companies, they have seen a deterioration, a decline in issues of mental health among their employees. And as every HR person knows, even before COVID, the issue of mental health and Americans with Disabilities Act and the Family Medical Leave Act has always been tricky for employers to navigate. But try navigating those issues now when 90% of your employees may be working from home. So Eric, can you talk about Advanced Local's view on this issue and what you guys are doing on this whole big question of overseeing men and women whom you literally don't see in person?
Sure. People now, as you said, are living at work. There's really no separation between your day-to-day work activities and your life as a human being, whether you're a parent, you're a spouse. They are just melding together, and there is absolutely no separation. So that is weighing on people. What also is weighing on people is the pandemic. There is a lot of anxiety about the pandemic. There's a lot of anxiety about the political climate. That is weighing on people. And we have seen an alarmingly high referral rate to our EAP system. So how do we address this? Oh, and I did not mention that most companies out there to combat the pandemic, financially anyway, have instituted layoffs. People have instituted wage reductions. There have been furloughs. There have been reductions in benefits, elimination of 401k matches, things of that nature. People are scared. People are very scared, and this is leading to an increased anxiety level. A lot of it is based upon being disconnected and not being fed enough information. So we have tried to be as transparent as we possibly can. We communicate as much information about the business, how well we're doing, and what we anticipate going forward. We are communicating. We're one of those companies that instituted a wage reduction. People understood it. People understood that it was necessary. Last week, we were pleased to announce that we have rescinded the wage reductions because of the astounding work of our employees. But we are trying to remain as connected as possible with them. Something else that we have instituted, and this starts from the top all the way down, is that you must speak to the employees that report to you on at least a daily basis. Emails are great, Skype is fun, and people, Zoom has revolutionized remote working. However, there is nothing like a conversation one-to-one with your employee. Doesn't even necessarily have to be about work, but it takes away this sense of isolation and disconnection from the organization. It leaves people less anxious, and these conversations can be about what's going on in your community. It can be about whatever is next up on your Netflix playlist. Just having that kind of communication, and every conversation our CEO has with the executive team. Who have you spoken with today? What did they have to say? And this just trickles down to the rest of the organization. Every supervisor is required to have these conversations. And we've also conducted surveys about what people are thinking and asked very direct questions. It appears to us that this type of communication is helpful and has relieved a great deal of the anxiety that people are feeling. The anxiety is still there in other regards, things that we can't control, but this communication is making things a lot easier for them.
Can you speak, Eric, a little bit about the issue of electronic communication policies? We know that many companies, many of our clients, I know Advanced Local does this as well, have benefited from these collaborative, cohesion building electronic efforts, such as virtual poker, virtual happy hours, just an increase in employee chat platforms. We know about video conferencing with Zoom, but just everything going on with Microsoft Teams and Slack and other forms of communication apps that bring people closer. We've seen the benefits of that, but we've also seen some downsides. We've also seen some people act a little too casually during these sort of communications, which frankly wouldn't be tolerated in a traditional office. And I think, Eric, if you just want to talk a little bit about what Advance does to ensure that the employees understand that even though they're not in the office, they still will be held to the same standards when it comes to communicating with one another.
You made an excellent point before about having policies in place surrounding conduct. We have a very comprehensive telecommunications policy, and we abide by it. The company-sponsored events like the virtual happy hours and things of that nature, while people have become more comfortable and more familiar during these types of sessions, we haven't seen an uptick in bad behavior or things that we feel would warrant constructive action, corrective action. However, we have also seen outside of company-provided venues that people are communicating. They're communicating on social media. And in some of those communications, they have been engaging in inappropriate conduct, using language that we don't approve of, engaging in topics that are inappropriate in the workplace. Normally, many people on this webinar are probably thinking, what do you care? It's outside of work. If they are engaging in this type of conduct with employees and it impacts the work environment, which is now greatly expanded, it is our business. And if people are feeling bullied, if people are being harassed, even though the method they're using for it is their own Facebook, entries or using Twitter or whatever venue they're using, it becomes our business when it impacts their ability to perform their job. We've seen some of that. We've had to engage in some counseling regarding that. But at the end of the day, again, we recognize that people are tense and we don't want to overly regulate something like that. We haven't seen any discrimination complaints, any harassment complaints arising out of that, but it's very possible that it could arise in the future. So we're keeping an eye on it. We're being diligent, but we are looking at things. And when things come to our attention about comments made on non-company provided mechanisms, we are taking a look at it. We're evaluating whether it is company related, whether it is workplace related.
And that's such an important point that I know HR folks around the country deal with. Do not fall into the trap, please. Do not fall into the trap of saying, well, this chat platform is not one that we underwrite. It's not one that we sponsor. These employees and supervisors have negotiated and worked on their own communicative sort of apparatus. So we, the employer, stay out of it. That is not the answer. Even if it's not your platform, even if you don't pay the Slack bill every month, if employees are being impacted, you need a mechanism in place where that complaint will be dealt with swiftly and aggressively, just as if it happened inside the physical workplace. And you mentioned, Advanced Local obviously is doing a wonderful job on this issue. Not all companies have been that successful, and we already have dealt with a Zoom sexual harassment claim, which started with the innocuous, voyeuristic sort of, hey, look at that bookshelf behind you. What's that book behind you to your left, behind your shoulder? And then it goes to or deteriorates into, maybe you should wear more lipstick on the next session when we have the sales folks here. And then it deteriorates into, would you please adjust your iPad, subordinate, so I can get a better look at your chest. These are real life cases that are happening. Some companies like Eric's have a very good apparatus to deal with that aggressively and swiftly. And each of you, as Alex said before, with policies and procedures and handbooks, make sure that the scope of that prohibition, when it comes to harassment, discrimination, retaliation, you make sure that the scope is sufficiently wide enough so it addresses this sort of conduct regardless of from where it happens. Alex, next issue, if you will. Wage and hour. Again, a whole separate seminar, I get it. But you are seeing wage and hour issues and violations and lawsuits that are unique to the virtual workplace. Can you touch on those for a couple minutes?
Sure, absolutely. I'll address that question, and then as we have about 12 minutes left, then we can get to some of the questions that are being posed in the Q&A. So the wage and hour issues, it goes back to a point that I touched upon when we're dealing with the workers' comp claims, Eric touched upon when dealing with the employee or supervisor or subordinate interaction, and that deals with control, okay, and the lack thereof. And when it comes to remote work arrangements, there is a potential, as you guys could all imagine, that some work is being performed off the clock. And the reason why that happens or that's possible is because unlike the in-person setting, there's no one, again, monitoring when that employee comes in, when that employee takes a break, when that employee comes, leaves the job site. So there's a potential for abuse. And with that abuse, there comes different things that could occur. The first thing is time theft, okay? And this is an issue that I've gotten questions from several clients. And time theft is a concept where an employee clocks in at 9 o'clock to get on the clock, right, to start earning wages, but at the same time fails to perform any work. That results in a fraudulent, I guess, use of time, the company's time, in wages being paid to the employee for lack of work. And going back to the policies, policies in employee handbooks should address that issue. The second aspect is the failure to pay wages. Okay, if an employer does not know that work is being performed, there's a potential that employee could, following either a termination or some dispute with the company, could say, "Hey guys, I worked every day off the clock. I was given constructive authority from my supervisor to perform that work, and I had no other choice but to do it. Otherwise, I would be subjected to termination or another disciplinary action." Now, that's a problem, right? Because employers are placed with the onus of knowing when their employees are working. And the only way to combat that is to have, again, a clear and effective written policy to address how employees can obtain authority to work overtime, for example, what the standard work schedule is, whether it be the normal one or a reduced one caused by the pandemic, et cetera, et cetera. The third issue arises from a point that Eric has previously touched upon, and that is the concept of wage reductions or furloughs or layoffs as a result of the pandemic. And what I'm talking about here, Peter, is the notion that for example, a salaried employee who was making $50,000 receives a pay cut of 50% attributed to business-related reasons, right? The lack of revenue coming into the company because of the pandemic. Although in most instances that reduction could work and would be legal, the problem is that you have classified that employee as exempt from overtime, but at the same time bringing their salary below the threshold of about $35,000. Now, what happens there is that the minute you do that, the minute you bring the wage reduction below the threshold, you are required to pay overtime, and failure to do so will inevitably result in a wage and hour lawsuit. And I know this may sound to be inconsequential or non-existent, but I can tell you over the last 6 months, Peter and I have been asked to assist in countless amount of wage and hour lawsuits, which in my opinion, Peter, I don't know if you would disagree, my opinion seems to be the most popular type of lawsuit we are facing in the pandemic. Just because of all the outside circumstances, the desire for financial certainty, the desire for wishing to get paid for every money that's due. Employees have become more disgruntled when they are not being paid, or when they feel they're not being paid. So those are really
Alex, it's also the most attractive for plaintiffs' lawyers looking for a quick hit on a collective action. So getting multiple employees involved in one lawsuit, looking for an institutional policy to challenge. So there is real exposure there.
Exactly.
And it's also very predictable, because we all know as employment law attorneys over the years, we always told our clients, if you're non-exempt, when you're home, you're home. Unless it's an extraordinary situation, we don't want you to have access to our system from your house. We don't want you to be clocking in and out from your house, because how do we monitor that effectively? So we really were very strict about not allowing our hourly folks to access work from home because of the inevitable wage and hour problem. And now here we are, everyone, or the majority of people, are working from home. So the situation has now arisen where everyone really needs to be careful with their wage and hour policies, because the risk has grown tremendously. Alex, what sort of questions are we getting?
So this question, I think will go to both Peter and Eric. The first question is, when a company decides to take temperatures before entry into the workplace, who would you assign, right? The logical answer would be, if you have a medical professional on your staff, assign the medical professional. But if you don't, who do you guys choose?
We're actually doing this. I spoke about our remote workforce before, but we also have printing and production and delivery functions as well. And these people have been reporting to work. Well, you know what? They've never stopped reporting to work. So before folks are entering our facilities, we are taking temperature. We have an HR professional taking temperature. It has not been a problem for us.
I will tell you, I had a situation, I think it was in April, where a company was very proud. They told me that they're doing temperature checks. We explained, well, that's nice, But if 40% of people are asymptomatic carriers who have COVID, the temperature check is not a panacea, but okay, it's a nice step. I asked them, who's doing the temperature check? Who's in charge of that? They had someone on their maintenance team who was doing temperature checks, who was recording information, was not sanitizing hands. And even though they tried to do it touchless, it actually generated more problems than not doing the temperature check. So if you're going to do temperature checks, the EEOC, the Equal Employment Opportunity Commission, says that's fine, but have the right people taking them, make sure the documentation and the records are either destroyed or kept confidentially. And remember, someone's temperature result is no one else's business.
That's absolutely right. There's also you spoke about temperature, taking somebody's temperature, and the fact that they don't have temperature walking into the facility doesn't necessarily mean they don't have the disease. And we've debated this back and forth. We came to the conclusion that the morale factor of employees seeing that we're doing everything we possibly can outweighed perhaps the fact that taking temperatures that will not identify folks with the virus.
And again, we have people on this teleconference I know who are from schools, educators. We have people from law enforcement who are watching today. Obviously, depending upon your business, temperature checks may be necessary, may be mandatory. But if you're going to do them and it's optional for you, just make sure you have the system in place. Alex, what other questions?
This is a good one as well. What are some of the do's and don'ts for employers who have employees that refuse to, for example, address the new normal, right? The ones who are refusing to come to a workplace that has been sanitized out of fear of the virus. The ones who refuse to do modified duties out of fear of the virus. And this goes, I'll address that one point before we go to Eric and Peter. And this is something that Peter touched upon before. And this is important that all employees understand. Before, 5 years ago, Peter and I used to advise some of you that a request for in-home work may not be a reasonable accommodation under the ADA, depending on the circumstances. Now, because we have been doing this for 7 months or 6 months, however long, please understand that employers cannot reject it outright, any request to continue working from home. So every case should be reviewed on a factual basis, on a case-by-case basis, and understand that many companies want to come back to in-person work, but just keep that in the back of your mind. So Eric and Peter, with that said, how do you address some of these employees that don't really want to play ball, so to speak?
We have not had that issue yet because any people reporting who are remote can do so voluntarily. If we allow them in for election night, it will be completely voluntary. They have already demonstrated that they can do their jobs very well remotely. For those people in our printing and production facilities, we have not had that problem. People want to report to work, and quite frankly, they cannot perform their job remotely. People have to work the printing presses. They need to use the inserters. But our remote workforce, people currently doing it, we have not had that issue because it's completely voluntary.
Alex, I think we have about 2 minutes left. Do you want to do one more quick question and then we'll wrap up?
Yeah, sure. And this is going to be the first point, Peter, that you raised during this webinar. If you can make a vaccine mandatory, can you do the same thing for a COVID test? And it's an issue you and I have been addressing since March. You want to take that?
You can, whatever you want. You want me to do it? I mean, we have clients who have decided that COVID testing is going to be mandatory. Typically in those situations, they will subsidize it. They will make it as accommodating as possible for the employees. Again, whether it works for your company, whether you're in healthcare, whether you're in a school, whether you're in a position where you're going to have large groups congregating together, you're going to have to make that call. But thus far, the EEOC, Department of Labor, have been very, very supportive of the employer's right to keep their employees safe. And if that means temperature tests, fine. If that means mandatory COVID testing, fine. And we'll see what happens with the election because that's going to be another issue that I guess we'll close with because we are running out of time. Depending upon what happens on November 3rd with the White House and with Congress, many of your workplaces are going to be impacted. We are going to be doing a seminar later in November or early December on the issue of the election results and what you can expect in 2021 in your workplace on issues of increases to minimum wage, issues of strength of unions, issue of the joint employer doctrine, issue of mandatory paid medical leave, all issues of W-2 versus 1099 misclassification. These issues will be directly determined by what happens over the next month, month and a half. So we'll stay in touch with you on all those issues. Please feel free to reach out to any of us with other questions that we did not have time to answer, whether it be security issues or anything like that. Thank you very much, and we wish you a wonderful rest of the day.